Hello everyone and welcome back. My name is Marina Chapelski and I am the founder of the Chapelski Law Group. We are a team of experienced immigration attorneys, and although we are headquartered in New York, we handle immigration cases across all 50 states of this country. Now the topic I am bringing you today is something that went completely viral on my TikTok account, and the response was so overwhelming, so many questions came flooding in, that I knew I needed to sit down and create a much more detailed and thorough explanation of this topic right here on this channel. What we are talking about today is something that sits at the very heart of every immigrant's deepest fears. How can you actually lose your United States citizenship? How does the denaturalization process work? And what are the specific circumstances that can result in someone being completely stripped of the citizenship they worked so hard to obtain? I want to be completely honest with you about something personal before we dive into the details. I have been a United States citizen for 33 years. 33 years. And I want you to know that even I, someone who has spent decades studying and practicing immigration law professionally, have occasionally had moments of anxiety where my mind wanders to the question of whether there is any possible way I could lose my citizenship and what I would do if that happened. If those thoughts cross my mind with all the knowledge and experience I have, I completely understand why they cross yours too. That is exactly why I did extensive and careful research on this subject, and why I am bringing you this detailed video today. I want you to have accurate, complete, and honest information so that you can understand your real situation and stop losing sleep over fears that may not apply to you at all. Before we get into the ways that someone can actually lose their United States citizenship, I want to start with genuinely good news, because I think it is important to lead with this, and I do not want you sitting through this entire video in a state of unnecessary panic. The honest reality is that the overwhelming majority of naturalized United States citizens, we are talking about 99% of people, do not have anything in their background that could lead to denaturalization. When you went through the process of becoming a United States citizen, USCIS put your entire record under a microscope. They vetted your background carefully and thoroughly. They looked at your history, your applications, your records, and everything that was available to them. And when they approved you for citizenship, that approval meant they reviewed what they could find and determined you qualified. For the vast majority of people, that approval stands permanently and without any serious threat. However, and this is the important part that you need to understand, there are situations where things surface after the fact. Surprises emerge. Information comes to light that was not available or was actively concealed during the original application process. And the central theme running through every single denaturalization case I have ever encountered or researched is this: any significant negative surprise that surfaces in your background after you have obtained citizenship, particularly anything that suggests you were not truthful or fully transparent during your application process, has the potential to put your citizenship at risk. This is not about minor errors or small oversights. This is about serious material misrepresentations and significant facts that were deliberately hidden. So let us go through each category carefully and clearly so you understand exactly what we are talking about and whether any of it applies to your situation. The number one reason that people lose their United States citizenship through denaturalization is that they lied about who they actually are. Not a small detail, their entire identity. What I mean by this is that someone created a completely false identity, a new name, a fabricated personal history, and used that manufactured identity to obtain a United States visa, enter the country, and eventually go through the naturalization process and receive citizenship, all under a name and identity that was never theirs to begin with. This is not a theoretical scenario. I have seen this happen with real people from countries all around the world. The mechanics of how it works are always essentially the same, even though the specific details vary from case to case, and understanding how it gets discovered is just as important as understanding how it happens in the first place. Let me give you a concrete example of exactly how this identity fraud scenario plays out in real life, because understanding the pattern helps you see how these cases get uncovered years or even decades later. Imagine someone from Pakistan who was in the United States, ran into serious immigration problems, and was eventually deported back to their home country. Once back in Pakistan, this person makes a calculated decision. They obtain new identity documents under a completely different name, essentially becoming a different person on paper. They apply for a new United States visa using this new fabricated identity. The consular officers reviewing the application have no way of connecting this new application to the previous person who was already deported because everything looks new and clean. The person is approved, comes back to the United States under the new name, meets and marries a United States citizen, and eventually goes through the naturalization process and receives citizenship. From the outside, it looks like a completely normal immigration story. So how does this kind of identity fraud eventually get discovered and come back to destroy everything the person built? Almost always the answer is this. It surfaces when the newly naturalized citizen tries to file immigration benefits for family members. Perhaps they want to bring over a spouse from their home country. Perhaps they want to petition for children or other relatives. When those family-based applications are filed, immigration officers begin pulling records and cross-referencing information from both countries, and that is when inconsistencies and contradictions start appearing. Names do not match. Dates do not line up. Prior immigration history from the first identity begins to surface and connect to the second identity. I want to be clear that I am using Pakistan as an example in this explanation, but I have personally seen this pattern of identity fraud and fake document procurement come from virtually every country in the world: Cambodia, India, Ukraine, Russia, African nations, Jamaica, the Republic of Georgia, and many others. The second major reason that people get denaturalized is that they lied about something deeply significant in their personal background, not necessarily their core identity, but a major fact or circumstance that would have been directly relevant and material to their citizenship application. Let me give you a specific and illustrative example of what this looks like in practice. Imagine someone who stated on their citizenship application that they had never been married simultaneously to multiple people. In other words, they denied any history of bigamy or polygamy. But in reality, this person had been or currently was married to multiple people at the same time. Now here is how something like this eventually gets discovered and brought to the surface even years after citizenship was granted. Perhaps one of the spouses in another country later files a VAWA petition that stands for the Violence Against Women Act, alleging abuse. When that VAWA petition is filed, and the immigration unit responsible for processing it begins their investigation, they start pulling marriage records, cross-referencing dates, and building a complete picture of the person's marital history. Suddenly it becomes apparent that this person was married to multiple individuals simultaneously, and that some of those marriages existed before they even became a citizen. That information goes directly into the citizenship record, and the denaturalization process can begin. Other examples of major background facts that can surface and trigger denaturalization proceedings include membership in a terrorist organization that was carefully concealed during the application process. If it comes out through intelligence, criminal investigation, or witness testimony that you were a long-standing member of a recognized terrorist organization and that membership was hidden when you applied for citizenship, that discovery can and absolutely will be used to strip you of your naturalized status, regardless of how many years have passed since you obtained it. The third category that can lead to denaturalization involves something that people sometimes do not realize applies to them even after they have already successfully obtained their citizenship. If within 5 years of becoming a United States citizen, you become a member of the Communist Party, join another totalitarian political party, or become involved in terrorist activities, whether those activities take place inside the United States or anywhere else in the world, your citizenship can be taken away from you. This 5-year window after naturalization is a specific and legally defined period during which the government can look at your post-citizenship behavior and use it as evidence that you were not genuinely committed to the principles and values of United States citizenship at the time you were naturalized. The law essentially says that if you joined a communist or totalitarian organization within 5 years of taking your oath, that timing raises serious questions about your true intentions when you swore that oath. I want to make sure this point about the 5-year window is completely clear because it surprises many people when they first hear it. Most people assume that once you receive your citizenship certificate and take your oath, your citizenship is yours permanently, and your future behavior, as long as it does not involve criminal activity, cannot threaten it. But that assumption is not entirely accurate. There is a specific post-naturalization period during which joining certain types of organizations or engaging in certain types of activities can be used as grounds for denaturalization. If within those first 5 years, after you become a citizen, you become involved with a communist party, a totalitarian regime, a war criminal organization, or any group connected to terrorism either domestically or internationally, and that involvement is discovered and documented, the government has legal grounds to begin proceedings to remove your citizenship. This is an important thing to understand and to take seriously. Now, I want to bring this out of the realm of pure legal theory and into the real world by sharing some actual examples of denaturalization cases, because I think hearing about real situations helps make this information land in a much more meaningful and memorable way. The first example is one that received significant public attention and became quite well known. There was a man from Ukraine who was nearly 90 years old when it was discovered that he had been involved with Nazi Germany during World War II. Specifically, he had worked at a concentration camp during the 1940s and had concealed this history completely when he eventually immigrated to the United States and obtained citizenship decades later. He consistently denied the accusations even as evidence mounted against him, but multiple witnesses who had been at the camp came forward and identified him specifically and credibly. The outcome of that Ukrainian case was that the man was denaturalized, his United States citizenship was formally stripped away, and he was deported. The legal proceedings that followed his deportation were extensive and complex, and ultimately he faced trial in Israel for his wartime activities. The key point from an immigration law perspective is this: the fact that 60, 70, or even 80 years had passed since the events that led to his denaturalization did not protect him. The passage of time does not erase or neutralize the legal basis for denaturalization when the underlying facts are serious enough. Concealing involvement in atrocities, war crimes, or crimes against humanity when applying for United States citizenship is one of the most serious categories of misrepresentation that exists, and the government has consistently demonstrated a willingness to pursue these cases even when the individuals involved are elderly and the events in question occurred generations ago. The second real-world example I want to share with you involves a client from Cambodia that came through our practice. This individual was suspected of having been a high-ranking military general who was personally involved in torture and the killing of civilians. As the investigation into his background deepened and evidence was gathered and corroborated, it became clear that this was not a case of mistaken identity or exaggerated accusations. The evidence pointed to genuine and serious involvement in war crimes and crimes against humanity that had been systematically concealed throughout his entire immigration history in the United States. Cases like this, and the Ukrainian example I described before, represent the far extreme end of the denaturalization spectrum, situations involving some of the most serious human rights violations imaginable, but they illustrate with absolute clarity that United States citizenship, while extraordinarily valuable and strongly protected, is ultimately a privilege that comes with conditions. I want to pause here and bring this back to something that is directly and practically relevant to the people watching this video right now, because I realize that the examples I have been discussing, Nazi war criminals, Cambodian military generals, people hiding entire fake identities, might feel very distant from your own life and situation. And for the overwhelming majority of you watching this video, they are distant from your situation. You are not hiding a fake identity. You are not involved in war crimes. You did not conceal membership in a terrorist organization. You went through the naturalization process honestly, and you have lived your life as a law-abiding person since then. For you, denaturalization is not a realistic threat, and I want you to hear that clearly and let it genuinely reassure you. The 99% figure I mentioned at the beginning of this video is real, and it applies to the vast majority of naturalized citizens watching right now. But here's where I want to speak directly to the smaller group of people who are watching this video and who do have something in their background that was not fully or accurately disclosed during their citizenship application process. Perhaps it was not something as extreme as a war crime or a fake identity. Perhaps it was something you genuinely convinced yourself was not important enough to disclose, or something you were afraid to mention, or something you hoped would never come up. If that describes your situation, I want you to hear this clearly and take it seriously. The time to address that issue is now, proactively, with the help of a qualified immigration attorney, before it surfaces on its own through some future application or investigation. Attempting to deal with a denaturalization proceeding after it has already been initiated is far more difficult, far more expensive, and far less likely to result in a favorable outcome than addressing a vulnerability in your record before it becomes a formal legal problem. Let me also address something that I hear come up frequently in conversations about denaturalization: the question of whether the current political and enforcement environment in the United States changes the risk calculus for naturalized citizens. The honest answer is that the current administration has expressed interest in using denaturalization more actively than previous administrations, particularly in cases involving serious crimes, fraud, and national security concerns. This does not mean that ordinary naturalized citizens who went through the process honestly and have lived law-abiding lives need to be afraid. But it does mean that people who have things in their background that were not properly disclosed should take the elevated enforcement environment seriously as an additional reason to address those issues proactively rather than hoping they never come to light. The legal tools and the political will to pursue denaturalization cases are both present in a way that makes ignoring known vulnerabilities more risky than it might have been in previous years. I also want to address the question of how denaturalization proceedings actually work from a procedural standpoint, because I think many people have a vague and somewhat frightening image of it happening suddenly and without warning or recourse. The reality is more structured than that. Denaturalization is a serious legal process that involves the federal court system. The government must file a civil or criminal action in federal court and must prove its case according to legal standards. The person facing denaturalization has the right to legal representation and the right to present a defense. The process takes time and involves multiple stages of legal proceedings. This does not mean it is easy to fight or that the outcome is not serious. It absolutely is serious, and the consequences of losing are permanent and life-altering. But it does mean that if you find yourself facing this situation, having a highly qualified immigration attorney by your side from the very beginning of the process is not optional. It is essential. So let me bring everything together and give you the clearest possible summary of everything we have covered today. There are three primary categories of circumstances that can lead to denaturalization and the loss of United States citizenship. The first is lying about your fundamental identity, creating a fake name, a fabricated background, and using a false identity to obtain your visa and citizenship. The second is concealing something deeply significant about your real background: a history of bigamy, membership in a terrorist organization, involvement in serious crimes or human rights violations, or other major facts that were material to your citizenship application. And the third is joining a communist party, a totalitarian organization, or engaging in terrorist activities within the first 5 years after you receive your citizenship. These are the three pillars of denaturalization law as it currently stands, and as it is being enforced in the United States today. Here is my final message to everyone watching today, and I want you to carry this with you. If you are a naturalized United States citizen who went through the process honestly, disclosed everything accurately, and have lived your life without involvement in the kinds of serious activities we discussed today, your citizenship is safe and you can breathe. Stop letting anxiety about something that does not apply to you steal your peace. But if you are someone who has a concern, even a small one, about something in your background that may not have been fully addressed during your application process, please do not wait and do not try to figure it out alone. Contact a qualified immigration attorney today. At the Chapelski Law Group, we work across all 50 states, and we have seen virtually every kind of immigration situation that exists. We are here to help you understand your real position and protect everything you have built in this country. If you found this video helpful, please give it a like, share it with people who need this information, and subscribe to our channel for more detailed immigration guidance just like this. We will see you in the next video.